Official announcement regarding more V's Alliant Credit Union.
Some of y'all have seen this video floating around. One, it's fake. Okay. Talking about this case. And the guy that started this is complaining about fiat currency. I tell people all the time if they understood what money was, they wouldn't be complaining. Money is nothing but an agreement between the parties. People think that they stole the gold, so they took away the money. Unfortunately, that to me is one of the worst teachings out there because my Bible tells me that nothing in this world has intrinsic value except for mankind. Everything else has a use, but man has the right to contract and declare the value of that commodity or that item or that contract. So, people's belief in money is the problem. Okay, so at one time in history, people used tulips for money. Another time in history, they used seashells for money. It's called a medium of exchange. Look, 1776, founding of the country. The colonies were using promissory notes. I went over this. What's a promissory note? It's a contract. This one right here, second row down, right here. Okay. New York, March 5th, 1776. Bills of exchange. Revolutionary War money. People say that paper has no value. Well, if paper has no value, how come contracts do? Because that's all the paper is a contract. Okay, here's the questions I asked. If at one time in history people used tulips and seashells for money, it appears that money or currency is nothing more than agreed upon contract between the parties, even if the parties, I meant to say, are two people or an entire society, aka the analogy of the fiat currency, the Federal Reserve notes. Since nothing on earth has intrinsic value except man, everything else has a use. That would mean that man has the right to declare the thing that is being used as money or currency and has the right to declare its value. That would mean it's a contract under the principles of contract. So, historically, various items such as beaver skins, shells, tobacco have been used as money, but these were not considered legal tender and had limited circulation. Well, that's correct. Precious metals like gold and silver, when stamped with a designated value, in other words, who stamped it? Man. Did the gold have value in and of itself? No. Man declared its value. Now the other party could agree to it or not agree to it. Have universally served as money and the medium of exchange. Money is considered the universal standard of value and measure of exchange. The power to coin and regulate money is an essential attribute of national sovereignty. While various commodities have been used as money, gold and silver have been preferred due to their desirable qualities for this purpose. Well, another word for purpose is use. Okay. Parties are not legally obligated to use the legal standards of value in their contracts. They can base their contracts on any medium of exchange that possesses measurable value, such as foreign money or other commodities, aka my buddy Mark in Minnesota who settled a traffic ticket with grains of rice. The Constitution and acts of Congress have established certain forms of money, such as coins of gold and silver, as legal tender. Private contracts cannot override this sovereign power. While parties can agree to use other forms of value in their contracts, these agreements are not enforceable as legal tender unless recognized by law. Money, in its broad sense, is a medium of exchange and a measure of value. It is a device and with value between those who use it, and its value can fluctuate like other commodities. The ordinary meaning of money includes any generally accepted medium of exchange, such as gold, coins, or notes. What's another word for a note? Contract. Used to trade goods and services. While money can be seen as an agreed upon medium of exchange between parties, its statutes, its legal tender, and its regulations are determined by national sovereignty and the law. Private agreements on what constitutes money are valid as long as they do not conflict with established legal principles. Therefore, while money can be part of a contract, its legal enforceability as currency is subject to the laws governing legal tender. Now, let's go to the next one. And then I asked follow up question. But even if the parties accept whatever is used as currency or money, it is still based on a belief that it has that value. And a belief can be wrong. When you say medium of exchange, that requires two people to agree to the terms of that exchange. Terms, for example, that product A has the declared value and product B that is given for the exchange has the same value. That, by definition, is a contract between parties. The use of items such as tulips or seashells as currency can be considered a contract under the principles of contract as it involves an agreement between two parties on the medium of exchange and its value. This is supported by several legal principles and cases. Now, let me pause for a second. When I say seashells and tulips, that was a national currency. Just do some research. Just Google historical seashells for money. You will find it, or tulips for money. It was some kind of tulip that was specially grown for that. Parties are not legally obligated to use legal standards of value at the time and place of the contract. They may contract with reference to foreign money or a medium of exchange not recognized as money by any system of laws, as long as it possesses value capable of being measured. And that's Mealy McFadden in 1870. New York Uniform Commercial Code recognizes that in currency exchanges, the money is not the medium of exchange, but rather the object of the exchange, thus constituting goods within the meaning of the UCC. This means that a contract to exchange currencies is subject to the UCC. So, when it's in this case, so that so called fiat is not considered money, it's considered goods. So, what is wrong with fiat? Now, historical cases have shown that contracts can be based on various forms of currency or items of value, even if those items are not recognized as legal tender. For example, during the Civil War, contracts were often made with the reference to Confederate currency or other items that served as medium of exchange at the time. Value of consideration in a contract can be determined by the agreed upon standard of value, even if the standard is not the legal currency. This principle is illustrated in cases where the value of Confederate currency was used as the basis for contracts and the courts recognized the agreed upon value despite the currency's lack of legal status. The inherent risk of fluctuation in the value of the chosen medium of exchange is recognized in contracts. Parties assume the risk of appreciation or depreciation in the value of the medium of exchange they have agreed upon. The use of items like tulips and seashells as currency can be seen as a valid contractual agreement provided that both parties agree on their value and the use of them as a medium of exchange. The value is based on the mutual belief and agreement, which is a fundamental aspect of contract law. See, then I ask another follow up question. So these principles technically apply to anything that is used as money and or currency, whether it is fiat, metals, notes, commodities, etc. At the end of it all, historically, it is all based on contract principles and the belief of the parties. The principles of contract law do apply to agreements involving various forms of money and currency, including fiat metals, notes, and commodities, as long as the value is agreed upon between the parties. This is supported by several cases. We already went over Neely and versus McFadden in the previous question. Number two, the case discusses the presumption that contracts are intended to be fulfilled in the currency referenced at the time of the contract. It emphasizes that the specific terms of the contract, including the type of currency, are crucial in determining the parties' intentions. Um, Number three, according to the New York Uniform Commercial Code, money is excluded as goods only when used as a medium of exchange. In currency exchange contract, money is treated as goods, and such contracts are subject to the code, indicating that contract law principles apply to currency exchanges. Number four, this case highlights the intention behind the contract terms as is critical. It discusses how currency can be treated as a commodity in contracts, and the specific term of the contract will determine whether it is treated as money or a commodity. Cook v. Lovett. This case underscores the private contracts cannot subvert the established standard of value set by the government. However, it acknowledges that parties can agree to barter or stipulate payment in a specific commodity, which will be recognized as binding if it excludes the recognition of legal money. Number five, this case explains that contracts payable in specific currency, such as silver, can be enforced as special contracts, even if the currency is not legal tender. The specific terms agreed upon by the parties are crucial in determining the enforceability of the contract. These cases collectively demonstrate contract law principles do apply to agreements involving various forms of money or currency, provided that the terms are clearly defined and agreed upon by the parties. The value agreed upon the parties, even if based on belief, is enforceable under contract law. It absolutely is. But this whole argument that they stole the gold and that fiat is this bad thing, which is what this guy put out. He supposedly filed a case in the Supreme Court, which they've not made a decision. That's why the video I showed at the beginning, claiming they've made a decision, was a bald-faced lie, which he admitted it was a lie. But he said people will understand the argument because of the fiat currency. Fiat currency, I don't care what it is. At the end of the day, the money is nothing but a contract between the parties. Contracts have value. It doesn't matter what it is. This is the kind of BS I see floating around out there that I keep warning people about.